Okay. Hi, and thank you for attending this webinar on basic estate planning documents. Today, we're going to talk about some of the basic Florida estate plan components that all adults in Florida should think about putting into place. My name is Kaitlin Fallon Wildoner, and I am an attorney barred in Florida and the owner of Wildoner Law PLLC. We have a physical office in Jacksonville, Florida, where we offer estate planning signings, but also offer virtual services and can help clients around the state of Florida. My team and I help you every step of the way and work with you to ensure your estate plan meets your goals. And once it is drafted, we continue to work together to ensure that it remains up to date and continues to meet your ever-changing life. While we do have our office in Jacksonville, we can do most and sometimes all of our work together virtually by using technology such as Zoom and Skype, and even just telephone calls and email. This helps us to continue to provide top-notch service throughout the COVID-19 pandemic and beyond. Before we get started, I do want to mention that there is no one-size-fits-all estate plan. As everyone has different goals, family structures, asset structures, and so on, an estate plan is a highly individualized thing. While I am an attorney and do help families set their estate plans up to meet their goals, I am not giving legal advice today in this webinar. If you are interested in learning more about how your goals can be achieved via an estate plan, please visit our website at wildonerlaw.com and set up an appointment to discuss your specific situation in detail, where I can then begin to give you individualized legal advice. So today we are going to discuss some of the must-have documents and components in your Florida estate plan. Generally speaking, the most important documents every Floridian adult should have are a will, also known as a last will and testament, a power of attorney, and a healthcare surrogate designation. If you have children, guardianship designations are also critical, and if you have your assets structured in a particular way, a trust may be necessary. So first we're going to talk about a will. Like I said, it's also known as a last will and testament. It's a document that sets forth your wishes regarding the distribution of your property and the care of your minor children. Wills must be signed by you as the testator, and your signature must be witnessed by two individuals who certify that they witnessed you signing the will. When we draft wills for our clients, we also include a self-proving affidavit, which is a notarized statement that is signed by you as the testator and the witnesses, indicating that you declared the will to be your will and that it was signed in the presence of those two witnesses. The self-proving affidavit allows the will to be admitted to probate without any additional proof of its authenticity. In addition to providing directions on how you want your assets to be distributed, a will can also make provisions for minor children, which we'll discuss again later. And it can also include wishes for your burial or cremation. While it's morbid to think about, those provisions can provide critical guidance for your family and friends after your passing, and can help to ensure your affairs are taken care of the way you want them to be. If you die without a will, in Florida, you're considered to be intestate. This means that your heirs will receive your assets as provided for in the Florida statutes. A judge may also make decisions about who cares for your minor children and how to divvy up your assets. At Wildoner Law, we provide annual reviews for our clients who have their wills drafted by us, and that does apply to clients who draft their wills virtually and in person. And we also offer discounted revisions if a major life change impacts your estate, such as having a new child, adopting a child, getting married, so on and so forth. The next document is a power of attorney. It's a legal document that delegates authority from one person, the principal, to another person, also known as the agent. A power of attorney can grant a variety of powers to the agent, and the principal can be very broad or may limit the power of attorney to only a few specific acts that the agent can take. Powers of attorney can be used to give someone the right to sell a car, a home, or other property. They can also be used to allow someone else access to your bank accounts, to sign a contract on your behalf, to make healthcare decisions, or sign legal documents on your behalf. There are three types of a power of attorney. There's a limited power of attorney, a general power of attorney, and a durable power of attorney. A limited power of attorney allows the agent authority to conduct a specific act on behalf of the principal, such as selling a home. A general power of attorney gives the agent very broad powers to act on behalf of the principal, though a list of the specific types of activities have to be included in the document. Both a limited and a general power of attorney stop. and they terminate if the principal becomes incapacitated. A durable power of attorney, however, remains in effect even if the principal becomes incapacitated. Most of the powers of attorney that I do in my practice for estate planning purposes are durable. In order to be valid, a power of attorney must be signed by the principal and 2 witnesses, plus a notary acknowledging the principal's signature. Next, we'll talk about a healthcare surrogate. A healthcare surrogate is a person that you authorize to make medical decisions on your behalf if you're unable to make your own healthcare decisions. This is a critical appointment, and you should only appoint someone whom you trust and with whom you've discussed your wishes. If you and your healthcare surrogate have not discussed your wishes, he or she would be responsible for making decisions based on your best interest. You can appoint anyone, family member or friend, to act in this role as long as they are an adult. Generally speaking, though, you will want to appoint someone with whom you have spoken about the appointment with. You want to discuss with them whether they are willing to act for you and make decisions on your behalf. This can be a really heavy role and one that not everyone will be okay with accepting, which is why it's important to have that discussion with the individual that you want to appoint as your healthcare surrogate. If you do not appoint someone to act as your healthcare surrogate and you are unable to make healthcare-related decisions, Florida law directs the doctors to a list of people in order to determine who can be the decision maker on your behalf. It goes anywhere from a guardian, if one has been appointed by the courts. It can be your spouse, your adult children, your parents, your adult siblings, or other adult relative. If you don't have any of those, a complete stranger may wind up making the decision for you. Some hospitals have a policy where a social worker from another hospital will make important healthcare medical decisions for you. A healthcare surrogate appointment must be signed and witnessed by 2 adults, and one of those 2 witnesses must be someone other than your spouse or a blood relative. Okay, if you have minor children, this is a big one. It is often part of another document that we already talked about, the will, but it is so important that I wanted to discuss it on its own. If you have minor children, it is super important for you to discuss with your spouse or the children's other parent, depending on your situation, who you would want to care for the child or children in the event you both pass away. Though for as important as it is, it's pretty simple to do. You will need to make a written declaration that appoints a guardian to serve if the minor's last surviving parent becomes incapacitated or dies. The declaration must include the full name of the minor child or children, their date of birth, and their social security number. This kind of situation can get sticky for parents who are separated or who were never together, but it's still important to meet with an attorney to discuss your options. We as parents have a duty to our children to ensure their safety and their protection, and naming a guardian is truly, I believe, part of that duty. It's something that I feel very strongly about and strongly encourage all parents of minor children to designate a pre-need guardian for their minor children in the event of your untimely passing. Okay, and the last type of document is a trust. And while not everyone needs a trust as part of their estate plan, there is a significant portion of the population that does, and it's likely a higher percentage than people must think. Trusts are not just for the rich and famous, they are for everyday people. And typically parents of minor children are big ones that will opt for the trust, as that can help to ensure, for example, life insurance policies are properly distributed to the children and are distributed in line with the parents' goals and hopes. A trust can be either revocable or irrevocable. Most of the trusts that we do with respect to estate planning are revocable, which allows you as the grantor/settlor to invest and manage the trust property throughout your lifetime. And with a revocable trust, you as the grantor/settlor are allowed to modify or terminate the trust as long as you're not incapacitated. One of the benefits to having a trust, as we kind of touched on, is if you have life insurance policies that you want to go to your children, if you allow them to pass to your children as is typical, the children or their guardians may wind up getting an influx of cash and not know what to do with it. For example, if a 22-year-old who's getting ready to graduate college or has just recently graduated college is all of a sudden has this windfall of a $500,000 life insurance policy, they may not be at a point in life where they're thinking about setting themselves up for future financial success, paying off any student loans they may have, buying a starter home, going to graduate school. The money may wind up being spent on something a little more frivolous. And a trust can help you to control what happens to the proceeds from your life insurance policy if you do pass away. It is important to note that in order for a trust to work properly, it has to be funded, which means that your assets must be formally transferred to the trust before your death to get the maximum benefit. Assets that are not properly transferred may be subject to the probate process. In our practice, we generally provide pour-over wills for our trust clients in an attempt to transfer any probate assets to the trust upon their passing. So here's our process for how we handle estate planning clients. At the initial contact, generally that is either through a webinar like this that we had the initial contact, and following this webinar you decide that you are interested in either getting an estate plan or updating yours. Once you make that initial contact, we'll generally have about a 15 to 20 minute telephone conversation. After that phone conversation, which is the purpose of that is for me to understand kind of some of what we're looking at as far as what your goals are, and to kind of start to get an idea of what type of documents we would need. We send you an intake form. There's 2 different forms of that intake form. The one form can be completely filled out online, computer, smartphone, tablet, and gets pushed right back to my email once it's done. The other way is through a printable PDF, which we send to you as well. Allows you to print it, handwrite in the information, and scan it back to us. Once we get that intake form back, we enter into the drafting phase. We'll schedule and hold a design plan meeting. Again, that can be done over the phone or some kind of technology. After that, we get to the drafting. We draft all of the documents that we discuss, and once they're drafted, we send them to you for your review and approval to ensure that we did get everything right, all names are spelled right, and that they're ready to be signed. Once we have the approval back from you, we go ahead and finalize the documents, and we schedule the signing, and we hold the signing. For local clients, the signing typically does take place at our Jacksonville office. We can do them virtually. We have had instances also where we send you the documents and do kind of a virtual discussion of what needs to happen. After that, your documents are done. You can check it off your to-do list for this year. But after that, we do move into the annual review phase, where we perform annual reviews to ensure the accuracy. And if you do need any revisions, we do offer discount revisions to clients. And generally, revisions are done, as I said before, when there's a new child, and a new marriage, different things like that. Generally, the annual review is really quick and painless. And as long as everything remains the same, then all of your documents remain the same and you don't need any revisions. If there are changes that need to be made on the annual review, that's when we go ahead and take those revisions into account. Okay, so those are kind of some of the basic and necessary documents for Florida adults when it comes to their estate plan. Here is our contact information. If you have any questions at all, or if you would like to discuss your goals in your estate plan, please reach out to us. My team and I truly enjoy helping families get their estate plans set up so that their dreams and their goals can be achieved when one member passes away. It can be a really big weight off of your shoulders and the shoulders of your family members, to know that this is done, that you've taken those proactive steps and your estate plan is done. It's going to be on an annual review, and any revisions that need to be done will be done on a discounted basis. So there's our physical office address, and as I said, it's in Jacksonville. Our office phone, our website. We do have a chat bot on the website, so sometimes that's an easy way to get in touch with us, just providing your information through that, and that gets pushed through to us, and we correspond either over email or telephone, whichever one you indicate, for the initial phone call and interaction. And you can also email us at the contact at Wildoner Law email. That way, we're sure to route your email to the proper person within the firm who can best help you. So again, if you have any questions, feel free to reach out to us. But that sums up the presentation today. Thank you all. Stay safe and stay healthy.